Thank you for joining us for today's webinar. Few housekeeping notes. For the benefit of all participants, attendee lines are muted. Should you have any questions that you'd like to submit, please submit them through the Q&A space, the question and answer space. If we can't address them, if we run out of time to address them during today's presentation, we'll follow up with you after the program. Also, today's webinar is going to be recorded and circulated to all the registrants via email after the event. So should you have any follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. So participation on the live webinar must be on a computer or laptop. Credit is not available for joining via mobile. I don't know why, but that's what we're told. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you'll need to enter that code word into the Q&A section of the screen. So again, if you're in New York, New Jersey, Pennsylvania, or Kansas, please listen for the code word given during the program, and then enter that into the Q&A section of the screen. If you don't have a license in these states, you can disregard that. Okay, so let's get started. Thank you for coming today. The topic we're covering is long-term care or LTC insurance, specifically investigating and litigating fraud, waste, and abuse, what we call FWA for shorthand, in the long-term care insurance context. Before we get started today, I'd like to introduce our team today. Our presenters have a ton of collective experience with this topic. We've litigated insurance fraud relating to LTC insurance as well as other types of insurance, and have litigated fraud in lots of other commercial contexts. We hope you will find something we say useful today. My name is Andrew Azarmi. I'm the head of Denton's Northern California Commercial Litigation Group, which is the firm's largest practice group. My practice is varied, though my focus is firmly on defending insurance companies and financial institutions nationally in life, annuities, LTC, disability insurance, and securities, most often associated with the insurer's business. My partner, Kelly Graff, is based in Los Angeles. You'll hear from her today. She's also very experienced in this space. She's defended our insurer clients from bad faith litigation for most of her career, and she's also prosecuted insurance fraud many times. Alina Pavlova is a senior managing associate in our New York City office. The three of our other presenters are based in California, and we're certainly proud of our work for insurers in California. Our practice is truly national in scope. We defend insurers in every region of the US. Alina is a core member of our team with experience in life insurance, securities, and LTC litigation, and specifically with fraud, waste, and abuse, or FWA. Last but not least, Sina Forozan is a managing associate in Northern California. He has extensive experience defending insurers, both in and out of the LTC space, and also has extensive experience litigating fraud in commercial contexts. In a past life, he even worked as a plaintiff attorney, which we try not to hold against him. Not too much anyways. So these are our presenters. It's myself, Kelly, Sina, and Alina. So before we jump into some of the do's and don'ts and specific content, one thing that I wanted to talk about was just sort of set the table about why we're here talking about LTC and specifically FWA today. And, one of the things that makes LTC unique is that really when we talk about LTC, we're largely talking about tax qualified LTC policies. So tax qualified LTC policies refers to policies that adhere to HIPAA. And in 1997, the legislature enacted as part of HIPAA provisions in the Internal Revenue Code, which allowed for a special type of long-term care insurance policy that would be tax qualified. In doing so, however, the legislature took it upon itself to actually draft and enact the specific terms and some of the certain requirements, such as annual certification requirements, various other legal requirements that needed to be written into those policies to qualify for the favored tax treatment. Now, of course, given that the hook that there was a favored tax treatment, insurance companies, after the enactment of HIPAA, really jumped into the business of selling qualified LTC policies. And so what we saw in 1997, in the early 2000s, was a lot of these policies were sold. And this leads to another point, which is that with qualified LTC right now, the claim arc is expected to increase for about the next 20 plus years. And that kind of makes sense, because in 1997 and the early 2000s, these policies were really marketed and sold to people who were probably in their middle age, in their 40s, 50s, maybe older, who were thinking about, who first had the income to buy this type of policy. This is not like an insurance for your car or certain types of liability insurance or even basic life insurance. This is, in many ways, you could view it as a luxury policy. And a lot of those people who were in their 50s, fast forward to 2023, 25 years later, that person is 75. And now they're getting to the age where they're facing some of the health conditions that, that these policies, were potentially intended to cover. Another unique aspect of the qualified LTC policies is that because they adhere to and really follow specific benefit triggers and coverage terms that were defined in a statute, that was the U.S. legislature wrote, not necessarily an insurance writer. A lot of the triggers, they leave a lot of gray area, and there's a lot of ability to be open to interpretation, and that can lend itself to the potential for fraud. There's some unique terms of long-term care insurance policies that are worth mentioning. One of them is the home care option. And this is an option that we've seen really in lots of different policies across different insurers. It's a very typical policy. And often that provision allows for the care to be by the spouse. Now, why does this matter? When you're in an assisted living facility or a memory care unit, it's a lot easier to understand what kind of care you're receiving, who's providing that care. There's often lots of licensed healthcare professionals that work within that care facility setting. But the home care option, there's the ability for the insured to stay in their home and even to be cared by their spouse. So they don't even necessarily need to have like an outside caretaker or a licensed, healthcare professional who's administering the care. And, in some instances, and I don't want to overstate how often this occurs, but, we've seen instances where that can lead to the potential for fraud. Sort of aligned with that, another term of these qualified LTC policies that can be problematic in the FWA context is the cash benefit option. Again, that's another term we've seen in many different LTC policies. And the cash benefit option can be problematic because in some of those terms, we don't even see a need for care provider invoices. So, for example, an insured could file a claim, be found eligible, and then they start receiving cash payments. And, the assumption is that they're using that for their long-term care, but there's not really a requirement that there be care provider invoices. There's also not a requirement that the care be by anyone other than perhaps their spouse. And so we've seen instances, and in fact, some of the case law that we'll briefly touch on today, it dealt with exactly those circumstances where it was the home care, there was not necessarily care provider invoices. And then when there was ultimately found to be fraud, that's why some of that was not immediately detected. Another aspect of these policies that can be, problematic is that, a lot of them do not have benefit caps. So they can be lifetime benefits with no maximums or very high caps. Sometimes we've seen the provisions are tied to life insurance policies, and there's a policy limit, like maybe a couple $1 million policy limit. So at least there's a max there. Other times you have policies with no caps and no end point. And that creates a situation where you can imagine if an insured goes on claim and they're like, 55 when they go on claim and they live till 85, that's 30 years of potential claim benefits. If, a lot of times these cash benefits are, 6 figures per year. It depends on how the policy was written, of course. But that becomes an issue where, there can be the potential for fraud. And what we've seen, and also what is in the case law, is often what you have is the insured may go on claim as a result of some legitimate adverse health event, like an acute event, like a medical event. And then what we don't realize is their doctors, in front of their doctors, they're getting better. But what the insurance company's told is something very different. And in fact, the leading case, which we'll look at in a moment, that's exactly what happened. The person had a serious health event and probably was legitimately entitled to be on claim for a certain amount of time. But then once after a certain amount of time, stopped telling the truth and started advocating and then ultimately lying to the insurer. And that was what was specifically found by the court in that case. And then another aspect of these policies that can be problematic is that often when they were sold, agents didn't understand them that well. And now we find that a lot of insureds and also treating physicians may not really understand what's covered. We've seen lots of instances of doctors really effectively treating them like disability policies. In fact, I think there's a tendency by insureds, doctors, and even courts, unfortunately, in my experience, to equate the LTC policies with disability policies. And they're very different policies, but there's a lot of educating that has to happen. And I think that also creates this problem where we're seeing, instances of fraud. And for sure, fraud in the insurance context is not unique to LTC. We took a case to trial last year on life insurance fraud and won, but that had, so it's not something that's unique to LTC, but there are certain aspects of LTC that I think are unique that create this serious risk. The last thing that I wanted to sort of point out was that there really is a real lack of precedent guiding LTC claims determinations. There has not been many significant decisions which guide insurers and how they're supposed to assess or interpret these benefit triggers. Even though there's a federal statute, there's really very little case law interpreting that statute. And that creates a problem too, because that creates the situations where insurance companies, and that's a problem that spans not just FWA, but in the FWA context, those gray areas can allow for abuse, and we've seen that. So, what do we do about it, right? One of the things that's happened in the last few years is the vacuum that previously existed on the law has begun to be filled to some extent. And I don't want to overstate that. In particular, in the federal courts of California, there have been some really helpful decisions. The leading decision is this Lincoln versus Dalal case that's cited here from 2020 that went all the way to a jury trial verdict and ultimately resulted in a declaratory judgment and invalidating the policy. Now, why is that important? Another thing that I probably should have had on the last slide is that by and large, in fact, I've yet to see an LTC policy that has a cancellation for fraud provision. And that may be for reasons that I don't know, but in any event, what we've seen is there's no cancellation for fraud provision in the qualified LTC policies. And that creates this problem where, understandably, the insurance company's probably primary remedy would be to invalidate the policy. I mean, that's kind of the logical thing. I mean, if you find out that someone's been defrauding you, that your first objective is you just don't want them on your books anymore. they've lied to you once, how can you ever trust they wouldn't lie to you again? And that's totally logical, and courts have agreed with that. Unfortunately, the lack of the cancellation for fraud provision in those policies means that we're subject to the developing law in this area. And that said, although the best case law has been in federal courts in California, the principles upon which they are based are not principles that should be unique to California, and they are not principles that should be unique to federal courts, frankly, because these are equitable power principles. And so we cited some other jurisdictional law just so you could see that, you know, there is this concept should be transferable to other jurisdictions. We're still waiting for case law to develop in that realm. With that said, I'm going to turn the table over to my colleague, Kelly Graff, and she can take it away.
Thanks, Andrew. Good morning and welcome. As Andrew mentioned, my name is Kelly Graff. I'm a partner here in Denton's LA office. I spend almost all my time representing insurers in bad faith litigation and coverage litigation. So it's a real pleasure to talk with you this morning and get you that CLE credit too. So our first due on the list is adopt a fraud, waste, and abuse detection process and protocol. This is essential for insurers in this business. And we're talking about a formalized process, a formalized protocol, not an ad hoc system. As I'm sure many of you know, these situations can follow similar patterns, but at the end of the day, each insured is different, and there's a lot of value to considering each insured on their own terms. And there are two big reasons why you need one of these processes. The first is pretty obvious. You want to be able to find fraudulent and abusive claims that are not meritorious. You need to be able to separate the wheat from the chaff in a way that is fair and efficient. The second reason, and this is the focus of a good amount of our presentation today, is you want to set yourself up for success in the event that there's litigation. And unfortunately, given current trends, there's only going to be more litigation concerning long-term care policies, not less. So consistency is key here. You want the same standards applied the same way across different insureds, because you don't want the same type of behavior raising concern as to one insured, but not for another. That makes you vulnerable to attack in litigation concerning coverage, because, just imagine a plaintiff's lawyer like Sina. Sorry, we said we weren't going to give you a hard time about that, but just imagine a plaintiff's lawyer looking at a claims file and seeing there's no uniform process. It's just a claims person's gut, or something that they just felt what didn't look right to them. That doesn't play well with triers of fact. I represent insurers a lot, and it's hard to imagine a litigant that is more disfavored than insurers in courts in California and across the country. So you want to be able to point to a fair and reasonable process. And to that end, software can provide valuable analytics. There are specialist vendors who can assist with this, but they're only part of what should be a robust process. And if you could move to the next slide, I'll talk about one particular process we've seen that's worked well in court. This is the red flag system. So what this means is the insurer has a set of 10 red flags to look out for. The claims professional reviewing the file sees 3 or more flags, I put 3 of these little clip art flags for a reason. It's not just one, it's 3 or more. And if there are 3 or more that come up, it gets elevated for further review. You can see the red flags that this particular insurer used and was discussed approvingly by a court. Basically, for each one, it's a determination of whether that particular category is consistent with what you'd expect with other representations the insured might make. So, for example, we have the first one. Deficit that the insured is claiming consistent with their diagnosis. And so it's similar with, the rest of these categories. There's not a particular age that is a red flag. It's is the diagnosis or prognosis, degree of deficit consistent with the claimant's age. And when analyzing this system, this red flag system, on a motion for summary judgment, which the insurer ended up winning, the court noted that only less than 1% of claims filed over the course of several years hit on 3 or more red flags. So it was an efficient process. It wasn't over identifying claims as potential problems, and it was just a trigger for further review as well. So it's not 3 flags, it's a fraudulent claim. There's a much more individualized process that went in after the 3 flags elevated this claim for review. And in the litigation that ultimately followed, this process helped the insurer explain its motivation when it initiated a fraud investigation and surveillance, and the further investigation tools that Zena and Alina will talk about later in the presentation. And it was just an important part of the insurer's story to the trier as a fact as to why it acted reasonably. It was not being arbitrary when it investigated the insured and ultimately denied her claim. And with that, I'll turn over to Alina to talk about the investigation process and surveillance and those tools.
Hi, everyone. My name is Alina. So when evaluating and dealing with fraud, like Kelly said, to set up yourself up for success, it's important not to rush to judgment. So what you want to keep in mind, if it does ever reach to that point, you want to keep in mind your jury and the story that you want to be able to tell them. And now you get to tell them. And at this point, or up to this point, the insured has been in charge of the narrative. They've been submitting claims, participating in face-to-face assessments, submitting their daily questionnaire submissions, submitting physician statements, giving you medical records, telling you a certain story that they want you to believe. But with suspected fraud on the table, you get to take over and rewrite that story and not only tell the truth, but expose their lies. But of course, you're going to be doing that in private for some time. But while you're exposing the story, it's important to not get overzealous and hasty and accidentally misstep and make the wrong strategic move and then find yourself exposed to a bad faith claim. So to ensure that you're proceeding partially, there are 3 investigation tools that you can use. And these are surveillance, a medical records review, and or an independent medical evaluation, or IME. And you can do these individually or in combination and Kelly already touched on this, but it's important to emphasize that each case and each insured is different. Each reported condition or disease is different. So the approach that you take for each of your potential fraud claims will vary based on each individual situation. And there's no one, molded way to do this. It's not all one size fits all situation. So you will have to, take these tools as ingredients and then come up with the recipe based on who your insured is. So one of the trustiest tools you can use, and you'll probably use it each time, is surveillance. And you want to observe your insured to see what's going on and, reveal any fraud through video capture. And again, for this tool or ingredient, you definitely want to keep your insured in mind and the kind of condition they're reporting and that gives rise to their claim. And it's generally good to have a large sample size of surveillance. So that means, several months' time, full days at a time, possibly a full week within a month, just to see what's going on and what they're doing and what their progress is like each day. And that's because each reported condition is different. How the condition presents itself is different. There may be flare-ups one day, but there may be a perfectly seemingly healthy person another. It's really varied. And so you don't want to jump ahead and jump to a conclusion when you have a video of your insured, seemingly living a normal life. To you, it may seem normal that day, but to them, it's just a good day and they're able to live normally, so to say. So again, don't rush to judgment. And what surveillance will be able to do, actually, and this was exposed in Dalal, the seminal case out of the Central District of California, the insured in that case was actually living a double life. And so that's something that you can keep in mind. If you have an insured, and that's why also it's important to have a sample size. If you have a system in place of surveilling your insured every single day for a week, maybe every other month or something, you can probably see what they're up to. Are they leaving their house at all? Are they leaving their house and going to the airport? Because that's what Mr. Dalal was doing, despite claiming to be, so cognitively impaired that he can't, live and do anything. Are they leaving their house and going to the gym and staying in the gym for 1 hour? These are very powerful indicators of whether there's fraud. But again, you need to be able to stay patient and develop that story and that sample size and see what they're doing before you make any conclusions. Again, don't rush to judgment. And again, keep in mind your insured's condition. That's very important. Like I mentioned, someone can be reporting that they're cognitively impaired because they have Alzheimer's. But Alzheimer's, it's not, even though it's degenerative and it's never not curable, they're never going to get better. There are good days and there are bad days. So if you catch your insured, leaving their house alone without supervision and going to the park alone and spending 20 minutes at the park, that doesn't necessarily mean they're lying. You want to be able to see that they're doing things alone every single day of, a week in a row for 3 months, and then start to draw out conclusions, because one walk in the park is just simply not enough. Or for example, if you have an insured that has muscular dystrophy and you catch them and, they're reporting to you that they can't bathe and go to the bathroom alone and can't walk and, just really can't use their arms and legs. But you catch one instance where, they're putting on a jacket and they seem to have free range of motion. Again, once is not enough. Muscular dystrophy is also a condition that comes and goes, it flares. There can be good days, there can be bad days. It's managed with medication. So you just want to be very patient with how you proceed with developing that story in terms of whether there's fraud and they're actually lying about their condition. And, with a large enough sample size, you'll be able to have that evidence in hand to then take it to the next step. And one of the other next steps that you can use, again, keeping in mind that each insured and each case is different, is a medical records review. If you decide to take that next step, and I will get into later how you will decide to do that, it's, you know, hiring a medical professional who's well-versed and, you know, dare I say, an expert in the condition that your insured is claiming, to look through the medical records and to help you out with, you know, catching that fraud. Does everything align? Are there inconsistencies? You know, a lot of the times doctors will know that the insured is trying to get benefits or is getting benefits, and they will advocate for their insured. And so you'll see medical records that are sometimes completely aligned with the condition that the insured is claiming. Or, and I've personally seen this, you'll see doctors who will, you know, very obviously take down whatever the insured is telling them on a given visit, you know, just so much pain and this can't move and that can't move. But then you continue reading through the notes and your medical records reviewer will point that out for you. And, you know, you see like, oh, perfectly healthy, you know, all vitals are normal, like able to walk in my office freely, things like that. And again, with the help of a medical evaluator not a medical evaluator, medical records reviewer who's well-versed in the condition, they will be able to pick out, you know, not just the obvious things, but things that just completely don't align with the condition, and point out to you that with this, you know, with this reported ailment or condition or, you know, whatever it is, the insured would never be able to act in the way that the medical record is reporting. And with the medical records reviewer, you also, you know, that's good why you should do surveillance. It's good to also give them the videos, because the more data points that they can have overall, just as an overall picture, the more they will be able to make a conclusion one way or another, whether the condition being reported is actually substantiated by the full picture that you're giving them. So medical records and surveillance, you know, they can take a look at your video and, for example, and say, yeah, you know, someone with Alzheimer's, it's perfectly fine that they can walk on a given day in the park for 20 minutes. Or, you know, makes perfect sense that they could put on a jacket, you know, in this manner. So, you know, you would have someone who's taking in all the information you're gathering and able to give you sort of like a expert opinion. And another thing that's important for you to do with your medical records reviewer is give them as many records as possible. And that's, of course, within reason. You know, you don't want to give your insured's records from the time of birth to present, but, you know, if they reported their condition on a certain day, you know, go back and get those medical records from that date, and then get as much of a range of doctors as possible. If there is a claimed condition, chances are they're seeing a specialist or a couple of specialists. And chances are the more records you have, the more likely there will be at least one doctor who kind of seems like an outlier and is not advocating for your insured. So that will be very easy for you to catch, you know, any consistencies within the medical record itself, because some doctors are just not on board with making sure your insured gets their LTC money. And the third available ingredient or tool in your toolbox is independent medical evaluation, or IME for short. Again, this tool is case dependent. You may not always use it. Sometimes it's useful, sometimes it may not be. You know, sometimes you have everything you need already up to date and you don't need the extra evaluation. So that just depends on the insured and, you know, the kind of reporting that's being done, the kind of condition that's being reported, and what you've gathered so far. And if you do decide to do an independent medical evaluation, again, it's important to get someone who's an expert and well-versed in the condition that your insured is reporting, so that you have, you know, someone who will see through any malingering right away. And, you know, an effective example of having someone who's well-versed in the condition, it was discussed in the case of Lincoln versus Dalal out of the Central District of California, where Mr. Dalal was given a test and he was reporting, you know, this variety of neurological conditions. He was, you know, allegedly both cognitively impaired and had, you know, basically none of his ADLs intact and needed help with with all of them. And I don't remember if we touched on what an ADL is, but it's an activity of daily living. It's one of the ways that you qualify for LTC coverage. So in a test administered to Mr. Dalal, he was shown specific cards with words on them, and he was asked to point to a word out of the 2 cards shown to him at any time. And he was that variation of cards on words was repeated 7 times. And I'm reading from the case, when Dr. Hinken, the doctor administering the test, showed Mr. Jalal a card that had the words flower and match and told him to point to flower, Mr. Jalal pointed to the word match. When Dr. Hinken showed him the card with the words screwdriver and comb and told him to point to comb, Mr. Jalal pointed to screwdriver. Overall, Mr. Dalal got all 7 cards wrong. Dr. Hinken testified that the fact that Mr. Dalal was wrong on all 7 tests showed not only that he was able to read the words accurately, but that he intentionally chose the wrong answer in an effort to appear like he had severe problems. If Mr. Dalal had been able to read, as he claimed, he would have gotten at least half of the questions right based on pure chance. So again, it's just a really funny example, in my view, how someone who is truly malingering could, be caught through an independent medical evaluation from someone who knows how to catch someone through a test like this. If you have a certain condition, there's probably things that you inherently will be able and not be able to do. And through an independent medical evaluation, that will come out. So it's a good tool to use if and when appropriate. Again, this is not a one-size-fits-all kind of deal. These are just ingredients in your toolbox. So Andrew, if you can switch to the next slide. So I hope you're all paying attention. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the word fraud, seen on your screen, into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time and it's on the screen, the code word is fraud. All right, next slide, please. So next, you have to do a gut check. And earlier I was talking about making decisions about whether to use certain tools in your toolbox, about determining whether you have fraud on your hands. And so you might be asking yourself, how do I decide to use what tool and when, and what do I do about this information? And the answer is to bring in your litigation counsel. And first, that's your in-house counsel who'll be able to make certain decisions. And one of these decisions may actually be to bring in outside counsel right away. And it's important to do that so that, there's a sensitive dynamic going on here. You have suspected fraud, and you have an understanding that if you make the wrong call, you're exposing yourself to a bad faith claim. So it's very sensitive at this point. You want to be able to proceed with caution, with the right advice, and have someone kind of guiding you through the way to tell you what to do and when, so that you're not suddenly, the bad guy in the situation, now having to go to court to answer for your mistakes instead of bringing them offensively. That's a situation you obviously want to try to avoid. So after you bring in litigation counsel in-house and in-house and outside, they will take a look through the file, and then they'll be able to tell you what the next step is. And a lot of the time, the next step may be continue doing what you're doing, continue paying out the claims, don't change anything. And as the counsel themselves take next step in deciding what the next step should be, which sometimes is surveillance, and sometimes it's asking for additional medical records, and sometimes asking for an independent medical evaluation. It just really depends on what the facts to date are. So continue paying the claim if your counsel so advises. Continue doing the surveying. If you haven't started, then start doing the surveying. And then once there's enough information gathered, there will be a decision made as to what your next step will be. And that's not always going to court. And that's, again, a decision that will will be made together based on all the evidence gathered. And now I will turn it over to Sina.
Thank you, Lena. Hi, everyone. My name is Sina Faruzan, and I'll be discussing with you the importance of your claim file, as well as some strategic options in LTC FWA matters. So I'll just start with the most obvious and pressing thing on everyone's mind. Who is this crazy man on the screen, and why is he so crazy? And I'm not talking about either myself or Andrew, but this man right here who, to my mind, probably it's because he's at work and not at this winding river. But relevant to this conversation, it's probably also because he decided to file litigation before tending to his claim file. This is what you look like to a jury in a courtroom if you do not build out your record before you litigate: conspiratorial and disorganized. So let's think for a bit about some of the lessons offered by Dalal and Shannon, the cases discussed by Alina and Andrew earlier today. What drove those cases? Obviously, surveillance, which is going to be a key part of any claim file. But beyond that, the courts in each respective case highlighted routine claim file materials that were critical in eliminating fraud and that are likely present in any of your claim files and will be very helpful for you in terms of building out your record and preparing for whatever strategic option you decide to take. So just to list a few: claim forms. In Dalal, a key part of Lincoln's strategy, the insurer there, was generating leverage through a high damages figure. This is going to drive settlement when you're at litigation. It's going to be able to enable you to potentially have a buyout of the policy. Part of the way Lincoln achieved this was by showing that Dalal's deception in that case occurred from the very beginning of the claim, therefore allowing them to maximize their damages because they could obviously look back to when they started paying from the very beginning. This is not easily shown from surveillance alone. Most insurers are not in the practice of requesting surveillance at the outset of a claim. That's typically something that's of a last resort. In Dalal, the court focused on the differences between medical records that existed prior to the claim, specifically a record that showed improved physical functionality, with the claim form itself that followed said medical records in time and falsely reported the husband required assistance for all activities of daily living. That was fraud, and in the court's words, in their order on the motion for summary judgment, it showed that the Dalal's deception occurred from the beginning. Key fact in that case. Call recordings. Not all insurance have this. Not all people make the call in to record their claims. But when they do, they can be very helpful to review. And typically where there's smoke, there's fire. And in Shannon, the smoke began early with the insured's first call reporting a very hard fall in a shower, a representation that was later contradicted by her treating physician, who recorded in his notes that Shannon said she fell in her bedroom and not the shower. So a routine comparison of those in your claim file will allow you to see early on what looks to be a red flag. Speaking of red flags, as Kelly discussed, each insurer should have such a system. And the key is to have a system designed not just to note red flags, but provide enough information that a statistical comparison can reveal when a particular insurance red flags are so numerous or so grave that it is a statistical outlier, and thus a case meriting closer attention to detail. This is not something that you just will rely on to advance your FWA case and help inform your decision-making, but this will be critical in a bad faith defense too. A red flag system explains your motivations. It justifies your later efforts. Medical records, these are an obvious one. Compare doctor notes to claim forms, compare notes to benefit eligibility assessments, and make sure to read between the lines. Doctors are often going to engage in some form of advocacy for their patient, but very few, I won't say all, but very few will go so far as to lie. Do they stop short of describing a person's cognitive impairment as severe, even though that is what the insured and their family attest to in each claim form? Do they stick rigidly to descriptions like moderate and mild? There is likely a reason for that, and it is one you should follow up on. Caregiver invoices, plans of care. These are just types of documents that LTC contracts typically call for as part of any chronically ill certification or as any sort of contractual prerequisite to paying out claim benefits. These are usually required, especially when the person is receiving care at a facility or from a third party. Sometimes policies have carve-outs if there's family provided care or some sort of cash benefit. But the key here is to not allow your claims team to get sloppy. If your policy requires a certain document, make sure you have it before you approve the claim. And do not waver on this requirement from year to year. You do not want to hand what could be an eventual opponent in litigation a colorable argument that you waived a policy requirement. And more critically, a fulsome, holistic look at someone's health over a period of time is what allows you to truly understand whether you have a person who's exaggerating or someone who's actually committing fraud. And that's the only way you can truly illustrate that to the court as well. So whatever your policy requires, get those forms, get them consistently. Independent medical reviews. We never need to rely on an insurance doctor alone. You should be subjecting your riskier insurance to medical reviews and of all types. This isn't to say that each type of medical review is fit for each case. It is not a one-size-fits-all solution. Everyone needs to think critically about what is before them, but do not leave a stone unturned. Not while that relationship is with the insurance knowledge, a healthy one that has medical authorizations on file that allow you to actually send in your experts or review their records. Claim letters are critical. You want to be articulating your position from the very beginning as explicitly as possible, and not just when you're denying their claim, but also when you're approving their claim. The story that you will litigate on is the one that exists within your claim letters. If you prove them based on ADLs and not a cognitive impairment, be very explicit that you prove them on ADLs and not a cognitive impairment. This will help with insurers who, for example, might have signs of Alzheimer's or dementia, but they don't actually have a cognitive impairment so severe, justifying their time on claim. Perhaps they have a couple activities of daily living that qualify, however. But people can improve physically. And so you might want to therefore later take that person off of claim. That's going to be harder to do if you weren't clear from the beginning that they're on claim for ADLs as opposed to, for instance, a cognitive impairment. So mind your gaps, build your record, and let's keep a couple things in mind as we think about ways to flesh out the claim file. FWA cases are unique. It's somewhat rare that a party knows well ahead of time that a case is going to end in litigation, which again isn't to say all cases do, and I'll be discussing more on that in a moment, but certainly a sizable amount will. So position yourself accordingly, and as I said, mind the gaps and build your record. If you have records that you're lacking, perhaps they're medical records, well, it's time to ask for them while they're on claim and you have medical authorizations. Is there an expert that you want them to be seen by? It's time to send that doctor in. Surveillance. If you started this at some point in time and then stopped, it's probably time to tee it up again. But you want to always build this for maximum effectiveness, and you want to be looping in your in-house counsel and perhaps your outside counsel. Not just for privilege reasons, although that's critical, as you do want to be thinking about the file you may eventually turn over. But also to just ensure that you're collecting the information in surveillance that you need to actually advance and inform your decision making. Be thoughtful when you set up your insurance. If you're having an insured, your surveillance, you're having an insured show up for a benefit eligibility assessment, it's probably good to track them on the way in, on the way out. If a proof of loss form historically shows the insured receives care on Mondays and Wednesdays, you should be surveilling them on Mondays and Wednesdays. In Trans-American Life versus Argudin, a case in the Central District of California, a key fact there was the insurer's ability to show that the insured was definitely not receiving home care on the days that the proof of claim stated they were. That's only something that can be made quite clear by surveillance. Loop your doctors in. We've discussed this a bit, but if you filled your gaps and you have medical records, you have good surveillance, and you need an expert opinion on what you have before you. Is this malingering? Is this fraud? Is this something less? Bring your medical team in. And you can show them what you've collected. Maybe the IME you performed the first time just barely passed. The insurer gave on an Oscar-worthy performance. But now you have surveillance that undercuts them, additional medical records that disprove a portion of their claim. You can show that to that doctor. You can get a better opinion, and you can clean up a bad fact, turn it into a good one, lock in a key witness, and in effect, create for yourself a medical expert that supports your case. One last note, we mentioned working with counsel. It's critical to do that, whether it's in-house or outside. But work with them to craft your exhibits. And what I mean by that is as your conclusions firm up, there's probably some outstanding questions you have for your insured. Something as simple as, you say you can't lift your arms above your head, but I have you fishing. You can't be left alone, but here's evidence of you at a casino. Don't wait for litigation. Work with counsel, send that detailed letter. All you're doing is really preparing your exhibits. And it's kind of hard to make a false step here, especially in coordination with counsel. If the tone is right and the evidence is strong, you've got a very good letter to send off. If they respond, you have probably more lies committed in writing, and if not, even better. Andrew, if you can go to the next slide. So I'm just going to transition for a moment to talk about what are some chief objectives and strategic options available to you in these types of matters. We've talked a whole lot in the abstract, so let's just make this a bit more concrete. And as you can see, I have these helpful little bubbles on the screen here to help make the point, starting from the top left. And I'll be discussing each of them in turn, but briefly, it's keep them on plane, deny and play it close to the vest, deny and let them know you know, and straight to court. I don't want to say that any of these options should be your first option or that they're all equally weighed. Each case is different, but these are roughly the 4 options you'll have. Next slide, please. So not all cases are fit for court, at least not right away. Sometimes you have smoke, but no fire. Gaps in your claim record that are too large, surveillance too inconclusive. Maybe they've just been on claim for too long and the about face is not a good look. You might just have a gut feeling, but nothing more. So what you do, as we see it, is you do not invite a bad faith claim by denying them before you're prepared to defend it. Instead, keep them on claim. But keep in mind, it doesn't always have to be forever, just for now. And there's no time like the present to improve claim practices and continue building out that record to better understand and inform your ultimate decision-making with respect to a claimant. You might ultimately end up keeping this person on claim. You might just have a wobbler ill fit for court. There could be any number of reasons, but you can continue digging to determine whether you have a real FW case on hand. And in the meantime, you're not incurring any liability. Next slide, please. Deny and play it close to the vest. Mum's the word on this one, but keep in mind, you are probably inviting litigation. Maybe the denial alone in some instances is enough to get the insurer to back down. Some people can tell when they've been caught with their hand in the cookie jar, but not everyone. And of course, you still have a policy on your books, one you probably want off, and most people do not walk away from a free lunch. So this is an option that will be the right move in some cases, but like I said, it is one that will probably invite litigation, and it is certainly time for you to begin finding fire if that is the case. Next slide, please. Deny and let them know you know. So I'll be very honest here. This entire exercise, this slide was largely just an opportunity for me to use the I know what you did last summer movie poster. But I also have some actual advice to offer here. If you catch someone red-handed, this might be an opportunity to deny and let them know that you know. At worst, you develop a litigation exhibit and invite them to respond. If they do, as stated earlier, it might just be more lies committed in writing. If not, it's probably just a great record that you've created through bad faith defense. You can offer a buyout in these types of cases. After all, you still want the policy off the books, and a quick buyout, while perhaps painful to the business, will be cheaper in the long run than actual litigation costs. And you are going to get them off the books before that person might actually develop a real claim, which can happen in these cases. But as always, you should be expecting litigation when you send out these types of letters. You should be building your record if you haven't perfected it already. Perhaps additional surveillance, medical record reviews, registered nurse reviews. There's a lot of options here to build out that record and get yourself the opinions that you'll be relying on. But you should know that this is an option available for you. Next slide, please. And finally, sometimes the move really is just to go to court. Sometimes you don't need to wait, and you do need to be the first person to tell the story the court will hear. I think it's important in these circumstances to be honest. Not every claim file is perfect. Sometimes there are early red flags that you ignored. Perhaps you gave them the benefit of the doubt. Don't bury your warrants. You're able to plead around most tricky issues, let's say statute of limitations, statute of repose, waiver, You can plead around these things, and it's better to present a clean story as it occurred than fudge the truth. At the end of the day, these cases are about one thing: it's who do you believe? And it is a whole lot easier to believe an honest company than one committed to presenting the best look, or one that's most, perhaps most favorable than the most honest one. And please remember, a picture is always worth 1,000 words. Do you want the judge picking up a complaint and saying a whole bunch of dry lingo about claims forms and representations this or representation that? Or is it just easier to illustrate it? If you have good surveillance, if you have good medical records, tell that story with those images. Insured told us they're confined to a wheelchair and do not drive. Here is a still of them driving and doing chores around the house. That is a great image. That is fraud, and anyone can pick that up and understand. And with that, I will be handing it back to Kelly.
Thank you. Our next section is about don't litigate without a clear strategy. I think every litigator and trial lawyer on this call today knows that a clear strategy from the beginning is critical to a successful litigation outcome. And the strategy is and should always be informed by what your end goals are. Often that's to avoid the policy. It could be a policy buyout. It could be a variety of things. But knowing the goal first is essential. And, having this strategy in place as soon as possible is also key. If you're going to be a plaintiff in a fraud lawsuit, the strategy and goals should be determined long before you file that lawsuit. It should be kind of in the works as you're evaluating, whether or not to file a lawsuit in the first place. And if an insured beats you to it and you're a defendant, oftentimes there are demand letters that you're getting before a lawsuit starts, or pushback letters from counsel that gets involved. And that can put you on notice that a lawsuit is imminent, and getting your litigation strategy in place at that early point is going to pay dividends later. As far as strategy itself goes, I would encourage you to not be afraid to go on the offensive if you're faced with obvious fraud. I think Andrew has mentioned that insurers can and do win these cases. Don't be afraid. As an example, consider if your objective is to avoid the policy, for example. If that's your objective, why wait until, why deny the policy and wait until an insured files a breach of contract or bad faith action in their preferred forum? You're better off putting the damning evidence, like the photos that Sina was describing, the really clear indicators of fraud, putting that out there in front of the trier of fact and force the insured, the fraudster, to respond. This can also affect their ability to find a counsel to represent them in some cases. There are some really good lawyers, the plaintiff's lawyers, who are going to take some cases and not others. And it helps to get the good facts out there as soon as possible. Even if the insured beats you to it, I'd encourage you to act like a plaintiff. Most of my clients are insurers. I know how hard it is to get into this mindset of kind of a plaintiff's lawyer prosecuting a fraud case. Oftentimes we're used to defending cases, not bringing them. But here, aggressive strategies really can be your friend. Consider a multifaceted litigation plan. with subpoenas, surveillance, more investigation, depose everybody under the sun, who could have knowledge. And this is key in my experience, because you might have one person who is willing to lie or is willing to sign a form when they didn't really do what the form says they did, right? It's a small act. It's something else to sit in a chair across from, a seasoned litigator in a deposition under oath, and responding to questions. And a lot of people aren't comfortable with that. And it can really be used as leverage in your case. And with that, I'll turn it over to Andrew to talk about willingness to try the case and go for it.
Thanks. Thanks, everyone. I think we're at the top of the hour. In fact, we've gone a minute over, so I want to be respectful of everyone's time. We're happy to stay on if anybody has any questions they'd like to send. You should also feel free to send us any questions. We're happy to answer questions about it. We honestly do live with this stuff every day. And so, please don't hesitate if you have any questions. Like I said, I know that it's the top of the hour, and so I want to give people their day back and their time back. We really appreciate you guys joining us. And if you do have any questions, feel free to let us know. We're happy to stay on, for a minute or two, if we can, and we'll always be willing to answer questions after. Thanks a lot. It looks like we do have one question here. Can you guys see what I'm looking at? There's a question from, I guess it's more of a comment. Wow. Okay. Identical twin. That's a really interesting.
Well, it's an interesting comment because it highlights the importance of making sure your surveillance is of the right person, right? And we've encountered that in some of our cases.
Yeah. So the last thing I forgot to mention, and I'm sorry for those of you who got off, you'll get your CLE certificate in about 30 days. There will be a link with the CLE certificate. You don't need to do anything else. And all you need, the code word is only if you're seeking credit in those 4 states, Kansas, New York, New Jersey, or Pennsylvania. But if you've put that in, then you're good. And you should receive the CLE certificate soon. Thanks a lot, everybody, for joining us. Have a great day.